right, I think everyone's in now. But hi, everyone. Thanks for joining us today. My name's Ashley. I'm the Communications Manager at the AADA, and I'm really pleased to be hosting this session with our experts at Moran Agnew. I'll just start with the housekeeping note. This webinar is being recorded, so if you need to step away at any point, we'll be sending you the link afterwards. You'll be able to catch up later, or you can share it amongst your network if you so wish as well. We'll have time for questions at the end. So Statutory and Bill have set aside some time to cover off anything that might pop up. If you think of something along the way and you want to ask along the way, you can pop it in the chat at the top, and we'll come back to them at the end. I just want to say, I think that we've got our chairman, David Blackhall, who's joined us today. I want to say hello to David. And I also wanted to give a quick welcome to our industry partners at the various state board, MTA state bodies, MTAQ, VACC, TACC, and the NTAWA. But most importantly, the reason we're all here, welcome to our dealer member attendees today. This session is for you. Statutory and Bill have a great presentation ready to go with your challenges and priorities in mind that have shaped what they're covering today. So thanks again for making the time to join us. Without much more waffle, I'm going to hand over to Bill and Statutory. They've come prepared to share their insights and their practical advice. So thanks so much to the both of you. We really appreciate your time and your expertise, and I'll hand it over to you to take it away from here.
Thanks for that, Ashley, and good afternoon, everyone. Look, before I do hand over the first part of the webinar to Bill, I did want to briefly explain the structure of the content of today's presentation and provide you with some context. So Bill, he'll first provide a background about the reform of the privacy laws in Australia, which has led to the introduction of this new law that allows individuals to sue other individuals as well as businesses like dealerships where there has been a serious invasion of a person's privacy. I think understanding just a little bit about the privacy laws is important, but we'll keep that part of today brief. And that's because the main reason we're all here today is to present content to you to help dealers understand practical things like, first, identifying risk areas in your dealership operations. Secondly, managing risks in your key relationships. So that's with your customers, the OEM, and with your staff. And we'll also speak about strategies to limit risk of a privacy breach occurring in the dealership. And last, we'll also share things with you that we think you can implement now in the dealership to limit your liability and exposure to pay compensation or other legal penalty because the dealership suffered a data breach or another event where it's found to have failed to protect a customer's right to privacy. So over to you, Bill.
Thanks for that, Statutory. So today we'll be covering a little bit about this new law. It's serious invasions of privacy. So we'll get into a little bit about the background and where it comes from, what it actually means, what is an invasion of privacy, looking at things like reasonable expectation of privacy and seriousness and the public interest, some of the defences, exemptions and consequences of an invasion of privacy. And then we'll be looking at, after we've done a little bit about the law, we'll be looking at specifically the impact to dealers around the country. And we'll take your questions at the end and obviously summarise. So the background is we already have a Privacy Act. It's been around since 1988. It has what's called the Australian Privacy Principles. So most of you attending today would be familiar with those. They regulate how you can manage data, how you hold it, to whom you can disclose it, how you collect it, the need for a privacy policy and so forth. So that's all in Schedule 1 to the Privacy Act. The government introduced two new schedules, Schedule 2 and Schedule 3. We'll be looking at Schedule 2 today, which is the serious invasion of privacy. So generally, privacy matters in Australia. Individuals couldn't sue other businesses or other individuals for invasions of privacy. All they could really do was complain to the regulator, the Australian Information Commissioner. And there would be a conciliation. What this new law does under Schedule 2 for serious invasions of privacy is gives the ability to individuals to sue organizations, whether they're businesses, dealers, governments, and other individuals. So in terms of rollout, the laws were passed on the 29th of November. Some parts of the tranche of amendments that came through were implemented on the 10th of December 2024. There were other amendments made to the Privacy Act, including giving more enforcement powers to the regulator, things to do with cross-border and sending information overseas, more rights for individuals, things called doxing, when you out people maliciously. But on the 10th of June, this new law of statutory tort of serious invasions of privacy was introduced. So prior to the 10th of June, no statutory right existed. So this law very much covers an intrusion to someone's seclusion or a misuse of their information. As I mentioned, it's part of Schedule 2 of the Act, and it borrows these concepts from the UK, from New Zealand, from Canada, a little bit from the US, brings them all together, puts them in the legislation, and sets them out in a unique way. We can get some kind of understanding about how the law will impact us because of the experience in various countries overseas. But for the most part, as I said, the things that you need to take away from today are, in the past, people could only complain to the regulator, like the Information Commissioner. Now they can sue a dealership. It's most likely that it's going to come up in the context of either a privacy breach or a data breach. So if you suffer a data breach at your dealership, you may be sued for an invasion of privacy. Also, if you've supplied information to a third party and you didn't have consent to do so, and they suffer a data breach or a privacy breach, again, you may be dragged into that litigation as well and be sued as facilitating that particular breach or invasion of that individual's privacy. And when we talk about privacy breaches, I don't necessarily just mean hacking or some kind of malicious activity. It can be an employee at your organization who takes information that they're not supposed to take or access and discloses it to someone. So it's very much regulating your internal systems as well as your security systems in terms of how it interfaces with the public. So it's quite wide-ranging, and that's the reason why we're here today, to sort of educate you about the consequences of these new laws. It has general application, so it applies to individuals can be sued, businesses can be sued, government departments can be sued, but only individuals can be the ones suing as a plaintiff. And it's not limited, unlike the rest of the Privacy Act, it's not limited to what are called APP entities, which are entities that turn over more than 3 mil a year, and most dealerships do, so they're regulated by the Privacy Act. This law applies to everyone, irrespective of their revenue. So what is it? A serious invasion of privacy involves either or of these two things, an intrusion upon seclusion or a misuse of private information. And a plaintiff, the person suing, would need to prove a reasonable expectation of privacy in all the circumstances, that invasion was intentional or reckless, that it was serious, and the public interest in privacy outweighed the general public interest to the community regarding that information. So the legislation sort of outlines and sets some criteria or factors regarding the issue of a reasonable expectation. It looks at things like the means, how it occurred. So if it was a malicious act, hacking into a system or using devices and technology, it will look into that, the purpose of the invasion, the relevant subjective circumstances of the particular individual, so age, occupation, cultural background, and whether that individual whose information was made public, they invited publicity like a celebrity, or they've always manifested a desire for privacy. So there's some of the relevant factors for whether there's a reasonable expectation of privacy in the circumstances. And there's a particular case in the UK that sets out a basic principle, which is it realizes that audiovisual information, videos or photos, have much more impact in the community. So if someone's taking covert video and audio of someone, that could be more likely to lead to an invasion of a serious invasion of privacy as opposed to other information. And there's been all sorts of cases regarding that are similar to this. There was cases involving Naomi Campbell sued, for example, and J.K. Rowling sued because she was videoed down the street with her children and her partner. That was deemed to be a serious invasion of privacy in the UK. And other celebrities as well have sued under this provision. Some have failed. Elton John, for example, failed because he was merely standing out the front of his house doing really nothing. And that didn't lend itself to a reasonable expectation of privacy. So what constitutes serious? Well, courts generally look at the degree of distress and harm and impact to dignity that might be caused. And they have consideration under the legislation to the ordinary sensibilities of a person in the position of that particular plaintiff who's suing, as well as the defendant's state of mind and conduct. So there's this kind of specific subjective test, as well as sort of removed objective test in terms of assessing the probable impact to someone's feelings about that invasion of privacy to make it serious. And then we look at the public interest as well as part of that balancing act between the right to people to be left alone versus something that may be in the public interest for others to know about. So there's this balancing act that the court has to do. There are some defences under the legislation, so they're set out in Section 8. Obviously, if you get consent to that information, so as a dealership, if you've gotten consent through your privacy policy, for example, that will be a defence. If you've got lawful authority, regulators and other investigation like prosecutions, police and so forth, they will have lawful authority. If it's necessary to disclose the information in emergency, that will be appropriate. So there are defences in the legislation. And there are also exemptions and limitations. So some common sense things, intelligence agencies and law enforcement bodies are exempt if they're engaging reasonably necessary conduct. Children are exempt from this because if they're under age 18, they're deemed to be not of sufficient level of understanding in relation to this. And journalists are also exempt so long as it constitutes journalistic material, which again is defined as having the character of news, current affairs, or documentary, or is commentary or opinion on that. And so one of the things that I've noticed since the 10th of June is the way that some stories are now reported in the media has already changed. There's a lot less tabloid journalism generated from Australia in a lot of the news, and because that's not covered by this serious invasion of privacy, because if it's tabloid journalism, if it's tabloid news, it can be those publishers could be sued for an invasion of privacy. And so that only extends so far. It has to be news, current affairs, or documentary. And there's limitations which are very similar to those under defamation. You've got 1 year from the day you find out about it to sue, or up to 3 years from when the invasion occurred. And if you are under 18 and it was about you, you've got until your 21st birthday to sue for an invasion of privacy. The court can order, if someone sues for a serious invasion of privacy, all sorts of things, compensatory damages, exemplary damages, depending on what the nature of the invasion is. Courts can injunct a party, so they can literally stop that party from doing something, taking things down off the internet, removing it from publication from social media, for example. They can order correction notices and destruction of materials and apology orders as well. What we anticipate is a lot of actions are going to come in the form of injunctions, so people moving quickly to stop something from spreading. One such example of this where it didn't work for a plaintiff was Max Mosley, who used to run many years ago, Formula One. And there was a lot of media attention about the fact that he was participating in these orgies with sex workers. And because there was a delay before he brought the application for an injunction, the courts in the UK there said, well, hang on, you took too long. This information is already out there. It's been spread far and wide all around the world. And because of that, we're not going to grant you an injunction because effectively that ship has sailed. So if you're the subject of an invasion of privacy, you need to move relatively quickly in order to get an injunction. But if you're on the receiving end, if you're the defendant, defending proceedings, you can look at those things, as well as whether that particular plaintiff has invited publicity or the extent that the information is already public. There's no limit to damages for economic loss, but if it's for non-economic loss, like personal injury type impact, that is capped at the moment at $478,550, which is parallel to what happens under defamation law as well. So the key thing to know about actions for invasion of privacy is someone can sue without them having actually shown that they've suffered loss and damage. It's actionable without that proof, and that helps the injunction process. So, for example, if there's a data breach or a privacy breach and information goes on the internet, they would be able to sue for that without having shown that they've suffered something already, any form of loss or damage at that time. So that's something very important to understand about these laws. And this has significant impacts if it's like a widespread data breach and a group of people get together as a class action to sue. So this could be quite significant for, I mean, there have been some dealers to date that have suffered data breaches, and in the past, those actions that have been generated by some law firms for data breaches against, like, for example, Optus and Medibank, they've been very much couched in terms of consumer law or breach of contract or negligence, but never privacy. These laws give the ability for a group of individuals to get together as a class to sue for a data breach. And we expect that to be happening probably within the next 12 to 18 months once there's a significant data breach that occurs. So that is pretty much what we want to focus on in terms of the law and what the law says. What we are here today is to talk about how this impacts dealerships and those people working within dealerships in terms of what they need to do. And where we see the most likely impact to dealerships and those individuals working at dealerships is in the context of either data breaches or privacy breaches, because not all privacy breaches are data breaches. This can come up in the context of financial services. We see a lot. So the provision of loans or insurance products, in the context of advertising and marketing, as well as how you run your dealerships in terms of managing employee information. That's very important as well. So there's a few dynamics to this, and we're going to take you through some of those situations now. So data breaches can result in a serious invasion of privacy, and they might invite proceedings against the organization that has held that information. And as I've just mentioned, it could be in the form of class actions. Whether you've been hacked as a result of a data breach is a separate consideration, because as I said at the start, you may suffer a data breach. You had that information. It's your responsibility to manage that information. So you may be sued. Even if you've been hacked, that information gets out there, whether you took sufficient steps to protect that information. It also comes up in the context of data breaches experienced by parties that you've supplied information to. And that comes up quite often in dealership arrangements as well. There's all sorts of third parties that you will disclose and a customer's individual personal information to along the line. So you can see how that really plays out. While 70% of data breaches, according to the regulator, are as a result of hacking, there's a huge chunk of data breaches and then other privacy breaches that aren't the result of hacking. They might be as a result of mistake, and they could lead to certain liability as well. So don't think of data breaches just being someone hacking into your system. There are all sorts of ways and means by which data breaches can occur. And one of the things that you would need to look at, and one of the other parts of the privacy tranche of laws that have just been passed, is having a specific privacy principle, 11.3, that deals with technical and organizational measures. And it's now an obligation on organizations to have reasonable steps to protect personal information, to include implementing technical and organizational measures. And it's not really defined in the legislation. There is guidance. And what that really means is the bigger you are, the more sensitive information that you hold and the more information that you deal with will increase your obligations to protect that information. And these are some of the allegations that the regulators have taken and made against, for example, Optus, that a huge company like Optus should have implemented greater technical and organizational measures in protecting their systems when they suffered a data breach a couple of years ago. Same with Australian Clinical Labs, who deals with health information, and same with Medibank, who deal with health information. All these organizations are very well resourced. They have significant amount of information that they control, and a lot of it is sensitive. So, for example, with Optus, they had patched one vulnerability, but apparently forgot to patch a separate vulnerability that had been there for a number of years. And that's one of the allegations that the regulator is making against Optus. So technical and organizational measures for security purposes really means not only your interface with the public and protecting your internet and systems from external threats, but also internal management. So minimizing data breaches, having staff training, compliance, investigations, having response plans for data breaches, having all those kind of systems in place to respond and deal with basically how you manage information. And in terms of collection and destruction, that's a huge part of it. How you collect the information, what you hold on to, how long you hold on to it, and what you do with it before you destroy or delete it. So, for example, you collect all sorts of information in different ways, driver's license and other contact details on test drives. You might have old contracts in your systems and service history. If for example, you will keep financial records for tax reasons and compliance purposes in that way. But if the customer no longer owns that car and it's well over from 7 years ago, why are you holding on to that information still? So in one sense, it's important to consider your destruction and retention policies, to audit information, to destroy information when you no longer need it for any legal reason. There's no purpose to holding on to it. Because if you do suffer a data breach, there's less information, there's less of a smaller pot of information that is potentially susceptible to hackers, for example. I'll now hand over to Statutory to deal with some case studies.
Thanks for that, Bill. So I think to demonstrate the practical application of what Bill just spoke about, how a data breach could result in a customer claiming the dealership has caused a serious invasion of their privacy. I'll now talk through two scenarios. So the first one, where an employee calls the breach, for example, let's say a staff member in your F&I team rings a customer, Mr. Smith, to tell him his loan application's been approved. Mr. Smith asks your staff member to email a copy of his loan application because Mr. Smith's having trouble accessing the digital copy received through the link from the bank. At the same time, your staff member receives the same request from another customer, Mr. Moran. The staff member downloads a copy of both loan applications. He goes to email Mr. Smith his loan application, but in that email, the staff member accidentally attaches Mr. Moran's loan application as well. The loan application includes Mr. Moran's personal and financial information. Mr. Smith rings you after receiving your email and tells you that he received Mr. Moran's document. So you now need to decide whether this event is in fact a data breach that you must notify the regulator, the OAIC, how on earth you explain this to Mr. Moran, and when speaking with him, how best to respond to limit the risk of him making a complaint to the regulator and pursuing a claim under the new tort for serious invasions of privacy. Mr. Moran is angry. He claims your staff acted recklessly and he threatens action because now another customer knows where he lives, where he works, and how much he earns. He claims he feels very angry and distressed that this information is known about him by a complete stranger. In the second example of where a data breach might occur is where the dealership system has been hacked and the databases that contain customer information are exposed. I think in both of these scenarios, the dealership is at risk of a claim that the data breach has caused a serious invasion of privacy. If Mr. Moran or any of the customers whose personal information was exposed when the dealership was hacked makes a claim for damages, what the court will do is look to see if the dealer took reasonable steps to protect the personal information of its customers. In other words, did the dealer take enough steps to prevent the accidental disclosure of Mr. Moran's information when it was emailed incorrectly to the wrong person? And in the second scenario, the exposure of the customer database. So as Bill mentioned, this new law extends a dealership's obligations by requiring dealerships to implement technical and organisational measures. What this means is that a court may decide that a dealership did not have good enough operational processes to prevent accidental sharing of Mr. Moran's loan application. For the second scenario, a court might decide that the dealership did not have a robust cybersecurity system to protect against hacking. So the big takeaway from this is that data breaches are not unlikely risks, and they're not limited to malicious events like hacking. A breach could be caused by simple human error or just a bad decision made by your staff. So I think as this new law is reported more about in the media, customers will become better informed about their rights, and some will feel empowered to assert a breach of their privacy against businesses. What it will come down to is how much time and resources did you, the dealer, invest to protect customer information and other data that you have a legal obligation to protect. They'll look at things like your policies, your IT systems, operational processes, and staff training programs. They'll all be scrutinised. Bill mentioned the Medibank and Optus breaches. One of the big challenges with both of those was that each of Medibank and Optus appeared not to have a suitable data destruction policy. Either that or their destruction policy was just not implemented well. As a result, the databases that were exposed through the hacking contained about 20 years worth of data, some related to customers who had not been customers of Optus or Medibank for many years. In those circumstances, I think it would be very difficult to justify that there was good reason to have retained personal information going back that many years, especially where the person had not been a customer for a long time. So the lesson here for dealerships is that to limit your legal liability and exposure to damages is to have a data destruction and retention policy that ensures information is regularly reviewed and de-identified or removed altogether from the dealership systems, and that the volume of information retained in the dealer databases is limited. The law expects that you must retain information that is only needed for business activities. I think the dealer departments to look at closely when doing this risk analysis is obviously your F&I and your service departments. In circumstances when your dealership databases are exposed in some way to a data breach, the dealership will be in a much stronger defensible position where the volume of customer information stored in the databases is limited, and that the data you have retained relate to current customers. So people who recently bought a car, had a car serviced with you, or the car still under warranty. Bill, I'll hand it back to you for the next part.
No worries. Thank you for that, Statutory. Moving on to another form, and I've touched upon this very briefly already, but advertising and engaging with customers. If you think about advertising and marketing, it can occur in multiple ways within a dealership. There's a lot of sharing of information within a dealership group, and sometimes dealership groups are actually composed of separate entities. You have to make sure in those situations, because one of the defenses to an invasion of privacy is consent, that you've got the consent in your privacy policies to be able to share that information with other partner or other dealerships within the dealership group if it's for advertising purposes. Another curious way that it operates is often dealers will share information with other third parties. I think of one such example is one of my clients. They participate in the Adelaide Rally, which is in November every year. And they sign up individual customers to participate in their group that participates in the Adelaide Rally. Other people can engage directly with Adelaide Rally to register their interest to be a participant in that. Where it becomes interesting is if you register through a dealer, oftentimes, or necessarily, Adelaide Rally will want to know those individual details, who's actually participating. So there's a necessary sharing of information between the dealer and the host, the Adelaide Rally, of the individuals that are participating in the Adelaide Rally generally. So they need to make sure that they've got their individuals' consent to distribute that information. And that's very important, because that's how oftentimes you'll find that you're added to marketing databases and I never signed up for them. Who is this particular entity? And that becomes even more critical if that third party suffers a data breach or some kind of privacy breach, where an individual then turns around and said, I don't even remember consenting to that entity having my information. How did they get it? And they'll look at perhaps a dealership in this instance of why they disclose that information to the third party. Again, if you've got consent, it's in your privacy policy, you'll be covered, and that will be a defense to an invasion of privacy. So you can see the risks that come up there regarding the collection and disclosure of information. And especially in the advertising context, a lot of information is then on-sold and just goes far and wide. So privacy policies, consent notices are very important. Amending your T's and C's if you're engaging in a particular event to show that you are specifically getting that person's consent to provide that information on. And that disclosure also comes up in another context, and that is the disclosure of information by dealers to distributors or manufacturers or OEMs, and OEMs often insist on this information. And it also comes up in a separate situation where dealers are often disclosing information to parts suppliers. Now, if it's the way you can navigate the parts suppliers is, does the parts supplier really need to know the individual who's involved, whose car it is? Can the car be identified, or the job be identified via the car rather than the individual, and not pass on the individual's name and contact number to the parts supplier? So if you think about just some simple things, you're minimizing risk in that way. But if you are providing an individual's, say, phone number or address, and even their name to a party like that, you will need to cover that off, both in your privacy policies or in other agreements, you will need to execute an agreement with the relevant parties to cover things like liability and indemnities and warranties for protecting that information. And the simplest way to think about it is that people's private information, their personal information, is an asset, and they've trusted you with that asset. And if you're going to provide a copy of it to another party, you have to make sure that they're protecting that asset as well, and that you've got the consent to do so. Because as I mentioned, there's now this new risk. For the very first time, individuals could sue you for participating in that disclosure and what might end up being a data breach or a privacy breach. Internally, you also need to think about your systems in place and whether everyone needs to know everything within your four walls. And this concept of separating, say, your service departments from your sales departments from management. If someone comes in to test drive a vehicle, the service department doesn't need to know that individual's contact details. And so there could be a wall notionally, but so they're separated from that. And likewise, vice versa, if someone comes into the service department, their sales team doesn't really need to know that. And we think of this instinctively also in relation to HR and employment. That is, not everyone within a dealership will know or have access to someone's HR file. We expect management and HR teams to keep that information siloed for very good reason. So it's the same kind of concept. Who needs to know the information? And by implementing appropriate practices and procedures, you're minimizing those risks associated with privacy breaches and data breaches for people who might be an employee one day, who then might not be an employee another day, and take that information with them. If they do that and they use that information, an individual may be looking at you and say, well, why did this individual have access to my information anyway? You know, if I came in to test drive a car, why did your employee who was in your service department, former employee who was in your service department, take my information and go? Why did you allow them access? So looking at those kind of practices and procedures internally. Same kind of concept comes up with insurance, financial services, and financial products. There's a lot of information that's collected as part of Know Your Client and identifying them, whether to extend loans and other products to them or insurance coverage. All sorts of things happen in that context. And those particular parties who extend those financial services through you often have their own privacy policies. You have to be satisfied that those privacy policies are sufficient and cover the information off, and that they sufficiently protect your customer and the individuals from any kind of exposure and cover you off for any threat of risk or liability. So look at those kind of concepts. We understand that customers need to be identified, often for money laundering purposes and counter-terrorism financing obligations. We get that. But just like in Optus, you know, they were holding onto information allegedly for up to about 20 years, and they didn't need to, especially in relation to former customers. And these kind of concepts also come out in terms of franchisor and franchisees. There's sometimes a trend for franchisors to say, hey, franchisee, give us the information of your customers, supply it up to us. Again, you need to cover those off in your privacy policies if they're insisting on it and have relevant data sharing agreements in place. Comes up in terms of agent and contractors, and also in the recruitment space, because we're often dealing with third-party recruiters, and there's a sharing of individuals' information between recruiter and dealership. So again, you need to make sure that you've got the appropriate processes in place to manage that particular information. It also comes up generally in employment. Speaking of recruitment, once a person is an employee, that's exempt from being personal information currently. It's regulated under the Fair Work Act as opposed to the Privacy Act. That may change in the future, but that doesn't stop the obligations in terms of invasions of privacy. And so what we've been seeing a lot over the last 10, 15 years is behavior and conduct outside of the workplace increasingly being judged by employers and disciplinary action being imposed on employees as to what they did or have done in their private life. And there might be, someone collecting that information from social media. So one example that happened recently was a particular person who happened to be a lawyer, funny enough, from Melbourne, travelled to Adelaide for the Gather Round Australian Rules thing that happens in April for the last couple of years. And they told their employer that they were chucking a sickie, they were effectively having a sick day. What then ended up happening, of course, is they posted all sorts of things on social media without telling their employer that they were going for Gather Round. Another employee saw the information, dobbed them in, and obviously when they got back, the proverbial hit the wall. And they were disciplined and fired as a result of that. And so this brings up a new challenge now since the 10th of June, whether that kind of action may have constituted an invasion of that person's privacy. Their social media was on private settings. It happened to be that one of their colleagues was one of their friends on Insta and mentioned the information, and that's how the situation unraveled. So there's a little bit of a precarious situation there as to what might have happened easily in the past might now be a little bit different. And another case that happened last year, which was a complaint to the privacy regulator, was there was a situation involving an employee who had a medical episode in the car park outside of work. The ambulance arrived, some employees saw the situation. The employee was then carted off to hospital. The employer then called the partner of the employee, said, how's the employee doing? Are they okay? What's the update? The partner told them, yeah, they're going to pull through, they're going to be okay, we expect this to happen, and so forth. The employer then sent an email to 110 employees reporting on the status of that particular employee. And so that employee made a complaint to the Privacy Commissioner and got compensation orders as a result. That was dealt as a complaint at that time under those laws. If that situation happened today, it would be much more significant, and there would be an ability for that employee to have sued for a serious invasion of privacy. So the consequences could have been much worse for that particular employer if it happened this year as opposed to a couple of years ago. So that's another way to think of it. It's not just a data breach in the traditional sense of hacking, it's how you manage information internally. And so there's all sorts of ways that this can come up and all sorts of consequences, who's got access to information, your contractors as well, whether you've got those technical and organizational measures in place, information management, security, audit the information, having responsible officers for privacy, conducting impact assessments. There's potentially employees are on the hook. It's not just the dealership. If the employee who conducted that privacy breach, who engaged in the privacy breach as well, they could be on the hook individually. So it's not just as organizations. It could be the directors of a dealership. It could be the information or IT department. It could be human resources. It could be the individual salesperson. So there's all sorts of accessorial liabilities, people who have facilitated a particular breach or invasion of privacy that may be liable. And so it doesn't just extend to external security. That's what we want to emphasize. It's how you run your business internally and looking how you manage the information. So this has impacts to things like employment agreements, privacy policies, workplace surveillance, and you should review them and update your policies generally across the board. And as Statutory mentioned, looking at your destruction and de-identification policies, how long you hold onto information and when you destroy it, and having those processes and procedures in place. So I know that's a lot to take in, and you'll have a copy of these slides after the session. We've also got a checklist for you, things that you can think about, whether you're litigation ready, because it might come up one day. You want to be prepared. Having your insurance coverage in place as well, your directors and officers policies, your D&O policies or your public liability policies, making sure you're covered for these types of situations. Looking at investing in IT, your information management and security posture. They're only as good as your individuals who have been trained. So having training for data breaches and response and management. Data breach response plans are available online for free at the OAIC's website. Whether you're complying with information standards, some dealerships have ISO 27000 or 27K compliance. So making sure you comply with those information standards and conduct audits and look at the information and review it and so forth. And update, we can only emphasize this enough, update your privacy policies, your terms and conditions, your service agreements, and so forth. It's really important to make sure that if you're collecting information from third parties, that you've got permission to do so. If you're disclosing an individual's information to third parties, that you've obtained consent to do so. And this comes up in all sorts of ways, as we mentioned, financial services, lending, insurance. It comes up in advertising and so forth, because there's potential liability, as we mentioned at the start, for the actions of third parties. If you've disclosed information to third parties, they suffer a breach, you may be liable. And of course, the big one, this is going to cost a lot. We appreciate that. You need to budget, you need to resource, you need to prioritize. And so think about that for the forthcoming financial year, perhaps. There's more privacy changes on the way, including the implementation of a fair and reasonable test, data breaches response being reduced from 30 days down to 72 hours amongst many, more rights for individuals, the ability for them to take action in different ways against all sorts of organizations. So the trends have generally been more resourcing to the regulators, more rights to individuals, more obligations to businesses, including dealerships. So to summarize, these new laws came in on the 10th of June amongst a package of other laws. Look at your privacy policies and reviewing them, your terms and conditions, update your processes and procedures, especially about information management and destruction, train your staff, resource and budget accordingly, think about the indirect consequences, insurance, for example, look at your agreements with third parties, your service agreements, for example, and obviously seek further advice. We're always here and happy to help as well. There are contact details. We're more than happy to take your questions now, but if you want to take something offline, there are phone numbers and our email addresses. We can help you in a number of ways. We do privacy policies, we do access requests for information, T's and C's, impact assessments. I do have a huge practice involving data breaches and responding to data breaches and dealing with the regulators, dealing with privacy complaints. So we're more than happy to assist you. If you'd like to give your feedback as to today's session, there's a QR code you can scan and give us your feedback for today. And as I mentioned, you will have a copy of these slides. I'll now hand back to Statutory.
Thanks for that, Bill. I think I'll do a quick wrap up before opening up questions. I know a few have come through the chat, which I think Ash will read out shortly. So I think when you read about this new law in the papers, as it will soon start to be reported, those articles will probably focus on salacious things to do with celebrities, being packed outside their home or at some private event. But what I say is don't be fooled by those articles, because as I think we've demonstrated today, this new law has a broad application, allowing individuals to pursue damages against other individuals and businesses like dealerships. So again, for example, where a data breach has occurred in that business and it's resulted in a serious invasion of a person's privacy. I mentioned earlier that individuals are becoming increasingly informed of their legal rights. I think the evolution of the privacy laws across the world, and now more recently in Australia, demonstrates that the laws to protect the rights of individuals will continue to strengthen with a spotlight on privacy and data. So to illustrate this, consider what happened years ago with Lara Bingle and Brendan Favola. I think many of you may remember what Brendan did. He took a photo of Lara in an intimate setting. That photo was sent to other people, which ultimately was then published by the media outlets. At the time, Lara did not have an ability to sue Brendan for an invasion of her privacy. If something like that happened now, Lara would likely be entitled to threaten an injunction to stop further publication of those photos and to sue Brendan personally for damages. What this means for business owners like you is that the law imposes a much greater duty of care, requiring you to take much more care in handling sensitive and personal information of your customers and your staff. So one of the changes which Bill mentioned that's expected for tranche 2 of the privacy law reforms is the reduction in time for businesses to respond to a suspected data breach, down from 30 days to 72 hours. I think that change alone probably shows you the direction the privacy laws are headed and how important it is for businesses to take action now in readiness to improve their dealerships' operational governance around privacy and data protection. So I think we've got a few minutes left, Ash, if you wanted to open up questions and read some from the chat.
Yeah, we got some interesting ones come through. I also got texted a few questions that I've added in there. So we'll start with Ray. He asked, can we insert in our HR onboarding documentation that if an employee has causes a breach, that if an employee has caused a breach, that the plaintiff can be directed to this person?
So you want to throw them under the bus? Yeah, I mean, there is no reason why you can put something like that in terms of notification to an employee if they engage in any breach, really, within the practice, within the dealership, that they could be held liable. It does, putting a statement like that doesn't excuse you from liability. It would be a bit of a stretch for an employer to say you're going to be liable for the breach in its entirety. I think that might be frowned upon and dealt with accordingly from a court, and they'll be circumvented anyway. But there is no reason why you can't forewarn an incoming employee about the potential risks that they face for causing a privacy breach or a data breach. But you still have the obligations to train that individual. You need to have your policies in place and deal with that framework, because if they don't know the situation, the employers still have a duty of care towards their employees. So that's not going to excuse you from undertaking training and having the appropriate policies in place.
For sure. I think Ray's made a point here in the chat again, which I think everyone can probably sympathise with on the call, which is he doesn't want to throw them under the bus necessarily, but he does want them to do their job correctly, which, I think everyone can share that sentiment in dealer land. Steve has asked, what implication does uploading customer delivery photos on our social media pages?
I think that comes down to consent, doesn't it, Bill? Like, do you have consent and it's broad enough that allows for you to use those photos and upload it to social media? Bill, do you want to add anything to that?
Yeah, it's as simple as that. I mean, always get their client's consent. And usually you would anyway when they, for the most part, especially if it's on like Insta or TikTok, they're going to be tagged in that particular reel or that photo or story, whatever you want to call it. And they would know in that sense. But in any event, it shouldn't even wait to that. You should, get their consent before the fact. If they haven't, there might be a case to say an invasion of privacy, especially if they're in the photo or their registration plate, for example, is unique. That might identify them as well. So yeah, the simple answer is, as Satiri mentioned, getting consent, which I imagine you would. I can't think of anyone that would post something like that, you would think, to social media without having obtained consent to begin with.
Yeah. Thanks, Bill and Satiri. I think Simone made a comment about maybe more than a question about a happy birthday broadcast could be more trouble than it's worth now. Any comments on that one?
I deliver the privacy training for our staff, and this came up last year for us. Because when I joined, it was that typical thing that happens at a lot of businesses. And now I'm going to sound like the wet blanket, aren't I? Because what was happening is when people joined, they were automatically put onto a list where it was mentioned when their birthday was, and that email or thing went out daily. And this was many years ago, and I suggested that that should be an opt-in rather than an opt-out process. And so that's the advice that I give to all employers now, which is if you're going to distribute information like that, make sure that you've gotten your employees' consent, that they are happy for everybody else to know when their birthday is or other personal information about them, just like that example that I gave earlier about that employee having the medical episode. So I'm sorry that I sound like a doomsayer and a wet blanket and a party pooper and whatever euphemism that you want to give. I get it. But you think about it, it's just respect and it's consent and it's doing right by individuals. And you don't want to make your employees uncomfortable for reasons like that. So
Bill's saying no more cake, everyone in the offices. That's what I'm getting.
Bill's just being a lawyer. How annoying.
Yes. Yeah. Lance has asked, he says it might be a silly question to follow on the delivery photo thing, but that if an image of a person vehicle includes rego plate constitute an invasion of privacy if there is no other identifying details in the post?
Yeah, it's that hard part. Is it private information potentially? Because say, for example, it's a unique name, there might be the ability to identify that person, or a unique combination, it might be able to identify them. Even if you don't have access, and most places don't have access, to a registration database, if that person could indirectly be identified from their rego plate, yeah, it could be. But in most instances, when I say that, in most instances, almost all instances, you wouldn't be able to do that.
Yeah.
So some unique combinations do. If it had like CEO MTA, there might be only a few people in that particular state that fit that description. So
yeah. I think you've answered one of the other questions that I got texted through, which is, are there any documents at the dealer level that should be updated? I think you covered that in some of your later slides. In terms of privacy policies and all that sort of thing. We have one from Nina. Does this apply for breaches from June 10 ongoing, or can it apply to data breaches that have happened in the last 3 years?
I would suggest that it's for any misuse of information since June 10. So if the misuse is ongoing, then it would be that period that is captured. Not so. What I'm saying is it could potentially capture data breaches that occurred prior to the 10th of June if there's a misuse that's ongoing. So, for example, if the data breach occurred on the 9th of June and the information went on to the internet, and those processes, those technical and organizational measures are failing and still failing, that might be something to consider. And whether sufficient action has been taken by the dealership post 10 June to get that information removed, to alert the authorities, to report it, and all that could also come into question. And this is something that's actually been alleged in each of the cases of Optus Medibank and Australian Clinical Labs. It's not only that they suffered the data breach on a particular date, but it's also how they responded to the data breach and their systems and their processes that were lacking. And in each instance, the regulators have made allegations about their response, their ongoing response and conduct not being sufficient. So theoretically, yes, it could. Practically, probably not.
Yeah, right. One final quick one, if you guys are all right with that. Daniel's asked, what happens in terms of a broker acting on behalf of a customer and requesting tax invoices for purchases?
Yeah, so The broker has to protect that information. The dealership has to protect the information. You need to have arrangements in place with the broker, and you need to have the individual's consent both ways. So whoever's dealing with the individual, they have to, if they're dealing with the broker would have had to get permission from the broker to supply the information onto you as a dealer and any information that's sent back. But yeah, you need to have covered off the broker there in the privacy policy, and then there needs to be an agreement between the broker and the dealership covering the management of that information to protect both parties.
Yep.
So that's what I meant before about like service agreements and so forth and T's and C's.
Cool. Awesome. I can see that there's a couple of questions we haven't quite made it to, so I'm going to take them on notice, and I can see who's asked those questions. So we'll come back to you after the session to give you a quick answer on that one via email, if that's all right with you guys. But thanks so much to Thierry and Bill from Moray and Agnew for taking us through everything today. We much appreciated. It was really informative, and thanks everyone as well for your engagement in the chat with those questions and for coming along today. It's been really enjoyable. So I hope everyone has a good rest of their day, and we'll see you on the next AADA webinar.